Hello friends, welcome. Friends, we all know that Vodafone Idea is in trouble because it has huge debt and it is not in the position to repay the debt to the government, which is going to be due from after September 2025 when the moratorium is going to end. Right? The government gave them some relief by converting certain portion of the debt to equity, which from 26.6% the DoT raised their equity in Vodafone Idea to 49%. But that is not going to solve the problem because by end of this year or maybe the beginning or end of this financial year, by 31st March 2026, there will be a payment due of 20,000 crores and most of that is going to be AGR. So I recorded a video to kind of justify that why DoT should bail Vodafone out, because the whole AGR case has been completely mismanaged and everybody contributed to that mismanagement, right? All the stakeholders contributed. So I gave the facts of the case. Now, in the same video, I said that I am going to record another video which is going to tell us clearly who committed what mistakes, because unless you know the facts, you will not be able to appreciate the mistake. And therefore, I am recording this video and I'll tell you friends that this video is going to be quite different from the video that I have recorded earlier, and there will be very minimal overlap. Now friends, because I know that it very difficult for the people to look at or go through different videos, and if somebody doesn't want to go to the past video, I have created this slide deck, and in this slide deck I have put out all the timelines of legal and regulatory shift which happened and numbered them from 1 to 14. So I would strongly encourage that you take a printout of this slide deck before you go through this presentation. So without any wasting further time, let me go through the article which I wrote on 14 September 2020, which kind of captures all this mistake, right? I'll try to capture it, do it as fast as possible without people getting confused, right? So let's be with me and you will be able to get a very good feel as to what went wrong. The first mistake was that the definition of revenue at the time when the migration package was signed, if you look at this slide, the migration package was signed on 22nd of July 2099. At that time, the definition of revenue was left undefined. Now, somebody may say that, look, the operators were really under huge compulsion and the DoT was also under pressure because they wanted the operators to bail themselves out. So there is no problem even if the definition of revenue was left undefined. It could have been defined later. That is all fine. But the problem was that it was supposed to be defined using a TRAI transparent consultation process. Now, when you do a consultation process, all the stakeholders, including DoT, has to contribute all information. But DoT did not put the consultant report during the time when the TRAI consultation was going on, which was a agency which DoT hired separately in order to help them get a clear understanding that what should be the definition of revenue. So they did it surreptitiously and they did not put that report before TDSAT, and therefore what happened was, at the time when this consultation was going on, the whatever recommendation that TRAI gave was not properly informed armed with all information. Then the second mistake that the DoT did was, it actually did not provide any justification when it rejected the report of or the recommendation of TRAI, because whenever you are when DoT is rejecting the definition which TRAI coined in the recommendation, which is that the non-telecom portion of the revenue should be treated separately, telecom portion should be treated separately, and the license fee should be calculated only on the portion of the telecom revenue. But that recommendation was rejected by DoT without providing any justification. So that created a problem, and that's why TRAI, TDSAT, on 7th July 2006 found that the TRAI consultation was not effective. So let's go to the document itself to see what TDSAT said. Now, I will show you that what TDSAT clearly said. It said that this is the judgment. I'm reading from the judgment. Coming to the recommendation of renowned expert in accounting, this is the consultant which TDSAT is referring to. It was noticed that the same was not communicated to TRAI, which has deprived the TRAI the benefit of considering that opinion. And therefore, if you go down below, it says that TDSAT said, in view of the fact, we have come to the conclusion that there has not been an effective consultation with TRAI, and they wanted an effective consultation with TRAI, and that's why this whole process was considered to be null and void, right, by TDSAT. So now this is the mistake. This is a very, very severe mistake, right? Now, what was mistake 3? The mistake 3 was that TRAI themselves could have asked, right, the DoT to provide the consultant report. And why TRAI could have? Because TRAI was fully empowered with that capability. How do I know that? If I go to the TRAI Act, and if you look at this para, which you can read through, provided also that the authority may request the central government to furnish all such information or documents as may be necessary for the purpose of making recommendation under the subclause blah blah blah. But TRAI did not do that, because if you look at the TRAI's review or this final, this paragraph, or sorry, not this. This one, where TRAI, this is the back reference. If you look at this, where TRAI is saying, if you look at, this is the TRAI, you can pause the video and have a look at it. TRAI is only saying that the definition proposed by TRAI has been recommending consistently. And it says that the license activity should be separate and excluding all the unlicensed activity separately. But it did not say to DoT that, look, you have rejected this recommendation without assigning any reason, but tell us that, it could have asked, DoT formally, that please provide us with that information, or even said that, look, this is not acceptable because you are rejecting this recommendation without any kind of reason, right? So they didn't do that. So that was mistake number 3. Then what was mistake number 4? The mistake number 4 was from TDSAT judgment. And let me tell you what is the mistake number 4 in real sense. Before we go to the document, I will just show you here. This is the SC order, right, of 19th January 2007. So let's understand this for the viewers. Therefore, I am putting everything graphically. What did TDSAT do? TDSAT basically said that the TRAI consultation was not effective, right? So they wanted a proper consultation to be done. So what happened was, because the judgment was against DoT, DoT went to Supreme Court, right? Because if you see, the color code is that whenever you find red, it is Supreme Court, right? Whenever it is green, it is TDSAT. So this is the color code you should be seeing. And if it is yellow, it is TRAI. So what Supreme Court said is that it allowed the DoT to contest all issues in TDSAT, even those which were settled. See here, even those which were settled, right, by TRAI, by this judgment. And what TDSAT did, so let's look at this. So what I'm writing here, that TDSAT in his judgment dated 30th August has rejected Union India's plea that SC has empowered it on 19th of January 2007. 19th of January 2007. Look at this, right? Let's read here. To urge all its contention, including those that were settled in earlier on 7th July 2006. 7th July 2006. 7th July 2006. This, right? So the extract of the SC order, we have basically, let me just go through the extract of the SC order so that you can basically have a look at it. So where do I get the extract of the SC order? This is the TDSAT order, AGR or judgment of 30th August 2007. 30th August 2007, right? This one, right? And this came when? This came after the SC order and after the TDSAT's judgment, where they told DoT that you have to put the consultant report before for TRAI, and TRAI has to do a extensive consultation, and on the basis of that, this judgment of TDSAT came in on 30th August 2007, right? So here, if you see here, what it is saying, let me go to the judgment, which is on 30th August 2007. What it is saying, Supreme Court passed an order of 19th January 2007. What was that? 19th January 2007. This one, right? So it passed an order of 19th January 2007 to urge all its conditions, including those which were settled in 7th July 2007 in before TDSAT, right? So it is the same order here. So what it is saying, pursuant to the direction of the TDSAT, in the impunged order, a fresh recommendation has been made by TRAI. In view thereof, we see no reason to interfere. The appeal is dismissed, and the appellant, which is basically DoT, however, has given the liberty to urge all its contention and raise this in the petition before TDSAT, right? So this is what Supreme Court said. But what TDSAT did? TDSAT said that we have considered the contention before the parties, and we are of the view that the appeal against the order of this tribunal, which was this order, this order, right? Okay, this order, appeal against the order against the tribunal. Okay, just a minute. Let me go through so many documents. Appeal against the order of the tribunal has become final and cannot be reopened. When an order becomes final, it cannot be challenged before the authority passing the order. It is a basic principle of our jurisprudence that authority passing an order cannot sit in itself in appeal against that order. Therefore, we have rejected the contention of the learned ASG, and he should be allowed to re-agitate the issues which are raised by way of appeal in the order dated 7th July 2006 before the Supreme Court. 7th July 2006 before the Supreme Court. Got it? So they said that, Supreme Court said that please re-agitate all the issues before TDSAT, and TDSAT said that the order is final, therefore I am not going to allow you to open the case. This became a huge issue, and that is the reason why this judgment of 11th of November 2011, which is a watershed judgment where the jurisdiction of TDSAT was also quashed by Supreme Court. They mentioned about this fact that we asked you to take all this into all the issues, allow DoT to agitate all the issues which were settled by this judgment, but you did not do that. Okay, so that is a major mistake. Now let's go to mistake number 5. SC, while passing the order of 19th January, did not look into the issue of jurisdiction of TDSAT. Now let's go to this slide deck again. What happened was, TDSAT judgment came 7th July 2006. DoT went to Supreme Court. Supreme Court said that, look, you can go before the TDSAT again and whatever issue was decided, you start agitating those issues again, right? So that's what they did. But later, when the SC judgment of 11th November 2011 came, when the TDSAT judgment which came on 30th of August 2007, which was after the TRAI came out with the full recommendation, with the consultant report, the Supreme Court found that TDSAT didn't have any jurisdiction. Oh, if there was no jurisdiction of TDSAT, this should have been done here. When the matter came to Supreme Court on 19th of January 2007, why waste so much amount of time? So here there was no jurisdiction, right? So that is a major mistake. So that's why I'm saying that it is not the operators which were responsible. Look at the way that the case was fought, right? So the question here is that if TDSAT didn't have the jurisdiction, then why the matter did not get investigated in 2007 itself when the matter came to SC? Why wait for 4 years, right? That is what. Now mistake number 6. This is very, very critical. So it is a mistake which Supreme Court, I believe that Supreme Court committed. Now Supreme Court in the judgment dated this 11th November 2011 looked into these issues of law, questions of law, substantial 4 questions of law. Whether DoT has right to re-agitate the same issue decided by TDSAT on 7th of July 2006 in lieu of SC dismissing DoT's plea so-and-so, whether TDSAT has jurisdiction to decide the terms and conditions of the license, whether DoT not filing an appeal against the order dated 7th July 2006 of TDSAT passed in favor of licensee, the said order has become final, whether the licensee can challenge the computation, whether the licensees can challenge the computation of AGR, and if so, at what stage and what ground, But it did not include one important question of law. How can DoT reject the recommendation of TRAI without assigning any reason? Why DoT did not allow a consultation with TRAI, which was fair, transparent, armed with all information, which TDSAT in their judgment dated 7 July 2006, which said, in view of the fact, we come to the conclusion that there has been not an effective consultation with TRAI. Now, if there was no effective consultation with TRAI, with TDSAT concluded, why Supreme Court ignored that fact? Because that is the question of law which Supreme Court should have taken. Because look, whenever a consultation is happening where DoT is a party, DoT may have huge amount of empowerment, but it is happening in public interest. So if DoT's interest cannot be divorced from the public interest, because DoT is sitting there to take care of public interest. So you cannot say that, look, I am fully empowered to do whatever I want, but I do not want the process, or I will not contribute to the process, which is the TRAI recommendation, to run with full fairness and transparency by submitting the consultant report. And that is what TDSAT found. So if TDSAT found that, the Supreme Court did not look at that issue as a question of law as it did with all the other items. You understand now what is the problem? So the reason it is important to know that the unilateralism of DoT, having set the expectation of a fair consultation with TRAI, triggered the biggest and the longest litigation lasting for 20 years and impacted the industry $23 billion of unnecessary outflow. Now the point is that why DoT was going through their consultation with a separate accountant, and why they were talking about total revenues. They wanted to prevent all this litigation, right? Because as soon as you dissect the revenue into compartments, there will be always a chance of arbitrage. Now, the whole intent of the hiring a consultant and talking about complete revenue was completely, blown out of, you can say that it was completely destroyed. The idea was destroyed because you had a litigation of 20 years anyway, right? Now, mistake number 7. SC in his judgment, dated 24th of November 2009, disregarded all the past fact, mistakes caused by the judicial process that the operator had no control. It attributed all the delays on the head of the operator. In this background, even if the SC held the definition of AGR of DoT right, it had virtually no rationale to impose such huge penalties, that too with interest, in light of the facts explained. So what SC did? So this is the judgment, 24th October 2019. Because what happened in the 11th November 2011 judgment, Supreme Court told TDSAT, look, you don't have any jurisdiction, but you can look at the case. We look at the terms of the contract or the demand of the DoT in terms of the license condition, which DoT itself can decide. So TDSAT did line by line determination of each and every demand of DoT, and then put that judgment, that they gave a judgment, and that was litigated by DoT, the appeal by DoT, both DoT as well as the operators appealed in Supreme Court, and Supreme Court on 24th November said, 24th October 2019 said that everything that you did is completely useless. DoT is fully empowered, the operator case is completely dismissed, and therefore the operator has been litigating for such a long period of time. They are wasting time, they don't want to pay, therefore I am going to impose huge penalty on the operators because you actually are litigating forever, right? That is what the perception SC got. But the case is right in front of you, which I am trying to describe. I am telling you the facts, right? You can clearly see what went wrong. So that is the mistake which Supreme Court did. Now, mistake number 8. SC in his order dated 11th of June bailed out PSUs out of the obligation of to pay license fee based on the same definition as is applicable to the. Now, this is a very interesting thing. You have to find out. So what happened was, as soon as this judgment came, Supreme Court judgment on 24th October 2019, DoT thought that, look, this judgment is talking about clubbing the revenues of all the operators, including ISP, PSU. So, because there is already a demand for the telecom operators, let me just place a demand for the PSUs or the ISP license. So, they created a demand which was huge, right? And this demand was something like this, right? If you see that there was a huge amount of demand for all the operators which were created by DoT, right? Now, when this demand was created, Supreme Court got very agitated. He said, look, we are focused with the mobile operator. Suddenly, how come there is another demand which DoT created on the PSUs? And therefore, what the Supreme Court did, and I'll show you the order of Supreme Court, which is very, very interesting. So now look at this order. Now look at this. This is a very important, by the way, very important order of Supreme Court, which this is how it starts, right? I'm just showing you how the order looks, and I'm going to go straight to those line items. What is this order all about? It was talking about it was analyzing the various licenses. Now, if you see here, this is where you should basically read this order. It says that the USL and ISP license, as against the phrase, so let me just start from the beginning. That would appear from the text above, the definition of the definition of revenue used in the USL and the ISP license, as against the phrase used for NLD and the IP2 license, are different. So what it basically saying is the USL and ISP license are different from the NLD and IP2 license, and therefore, since most of the PSUs are holding NLD and IP2 license, and therefore they should be treated differently. And then there is one more logic that has been used here. It basically said that in public interest, right, the PSU should be bailed out because the PSUs are not providing mobile services, and they are mainly providing services for their own purpose, not for commercial purpose, right? They are not commercial service providers. Now, there is a huge problem with this Supreme Court argument, and let me tell you why. Because if you look at the NetMagic case, when the NetMagic case, which I'm going to talk about, came into before the TDSAT, I analyzed this case thoroughly, and I wrote an article on 10th of October 2023. Now, I extracted this information from the TDSAT judgment on the NetMagic case. So, what is the NetMagic case? What happened is that the PSUs were bailed out. Now, NetMagic was a private ISP operator. Now, the private ISP operator was given the same kind of demand by DoT, because DoT said that, look, it is the PSUs which were bailed out. Private operators have not been bailed out. Therefore, your revenue has to be clubbed with the non-telecom part of the revenue. So, the NetMagic went to TDSAT and filed a case against DoT saying that, look, I am aggrieved. I can't pay that much amount of demand. So when TDSAT looked into the case, it kind of gave a very good insight. What it said was, and this is in a mix from various judgments, but I'll tell you the gist of this whole issue because it will become very difficult for me to point to each and every document, though I have read each and every document. If you look at the TDSAT, the SC order, right, on which they were trying to bail out the PSUs, what did they say? The USL and the ISP license are different from the NLD and the IP2 license, right? Note this point. Now, here you will find that this is the list of PSUs. You will find that, okay, some PSUs have NLD license, some PSUs have IP2 license, but you will see many PSUs have ISP licenses, and they are commercial in nature. For example, RailTel, commercial, they are providing rail wire services. So, it is not that they are using this license for their own internal purpose. They were also providing commercial services. So, if the USL and the ISP terms were similar in nature, which the Supreme Court said here that the USP license, the phrases used were different from the NLD IP2 license, then how come the ISP PSU operators were bailed out and the mobile operators were not? It's very difficult to understand this, right? These commercial, the public interest issues which Supreme Court raised were also applicable for the mobile operators, right? It is not that the mobile operators, if they go out of business, is not a public interest issue, okay? So I find it very, very strange, and that is why I am bringing this issue before you to talk about. So therefore, this is what is, you should read this. You pause this or you go to my website and take this article, you can read this article and paste a link of this article in the description. Then the preliminary assessment issue, which is pretty important. See, what happened was the SC judgment of 1st September 2020 included all the DoT's preliminary assessment as final assessment. Now, DoT might have committed some mistake. There should have been some opportunity for the operators to correct the mistakes. But Supreme Court in this judgment was so harsh because they thought, it got an impression that operators are deliberately delaying and not paying. Probably didn't get a bird's eye view of all this which I am trying to explain to you. right? In this, you can see it. It is right there. Somebody has to take the effort to read the documents, and you will understand it. It is not that the operators alone to be blamed. It is the whole system became dysfunctional. Okay, so therefore this is a major problem which I see. So then mistake number 10, what was the mistake by the telecom operators? The telecom operators were also committed a lot of mistakes. I'll tell you what the mistakes, because at that time the spectrum was given free, bundled with the license. Now you were getting spectrum free, so you were very happy. So you never went to the government before the 2010 auction, 3G auction, that look, this license fee or revenue share license fee has outlived it's a utility. So let's now go to the full auction mode, and we are willing to basically participate in the auction and take spectrum through auction, right? Rather than having two regimes simultaneously running in parallel. One is the revenue share as well as the auction. And when Ratan Tata offered to pay 1500 crores for CDMA license, people ridiculed him. That if he has money that he should be paying to the Prime Minister Relief Fund. So it is not that the operators also were completely can be considered as angel and did not really. They should have seen this coming. They should have taken precaution to de-risk their business, right? In a manner that, like what Supreme Court said, to carve out the non-telecom part of their business out of the telecom part of their business. And the same things with the PSU should also have done. Now, if the Supreme Court says that, look, my main premises in the Supreme Court judgment is this particular judgment, which I showed you. Supreme Court argued that, look, the reason I don't believe the operators is because they actually had a full opportunity to carve out the non-telecom part of their revenue in a different company, which is a non-licensed company. But the same argument is applicable for PSUs also. How can you just have one argument for the operator and one argument for the PSUs, right? Do you agree what I'm saying? Anyway, so the conclusion is that it is clear from the above discussion that the mistakes have been committed all around. So how can, everybody can be so insensitive to this whole issue? Not even the courts cannot be insensitive. The DoT, who has the responsibility to make the sector competitive, can't be so insensitive. That is the reason why, friends, I did this video yesterday where I said that why it is so important to bail Vodafone Idea out. And I'm repeating this video so that people, actually it's not a repetition. There are so many things which I could not talk about in the past video which I'm spoken here. But there are many other things which have got missed out because there are so many documents to refer to. And I can't point out to all the documents. I've taken the pain to capture this in as simple and as efficient as possible. Maybe I have been successful. Just give me your feedback whether you find this video useful. And this is what the information should be in the public domain, because it's very difficult to read through all these documents, friends. There are so many documents you have to read through and then analyze it and present it in a manner that people can appreciate what is going on. It's a very difficult task. I've tried my level best. I may have been successful. I don't know. I need your feedback and let me know whether this has been a fruitful exercise and it has helped to understand this complex issue. Thank you, friends, for your time. I know this is the part 2 of the video, and I think that I have done enough on AGR. Unless a new issue crops up, I probably will not do any other video. Thank you, friends, for your time, for listening till the end. I'll come back with a new video next time on a new topic.